Yes, hello.
Hello, Amber.
Amber, hi. Yeah, Amber is what's your title exactly? We just call you the compliance and AML expert guru. So it's like anything related to legal stuff, we just point to you. So why don't you do the introductions here, Amber?
Sure. My name is Amber Scott. I'm the founder, CEO, and Chief Anti-Money Laundering Ninja at Outlier Compliance Group. My business cards actually do say ninja. This is what happens when nerds get to make up our own titles. And when I started out, I was really averse to corporate titles. We've grown up a little since then, but probably not much. Our practice is primarily in anti-money laundering. So in short, we try to help keep businesses out of trouble. And with me, I have Laurie Stein, who is a partner at OSLER, which is, to my mind, absolutely the best startup law firm in the Canadian scene. She has done some incredible work, including being the lawyer who stood up and argued for 3IQ to be able to have a Bitcoin fund in Canada, which is such a big part of why we have an incredible flourishing ecosystem today, where we have several Bitcoin ETFs where other countries are struggling to get their first one off the ground. And Laurie, is there anything that you wanted me to add to that before we jump in?
No, that's fine. Hi, everyone. It's nice to be here. I don't typically get to attend hackathons, so I'm feeling kind of, in the trenches today. So thanks for the invite.
Excellent. And Jerry, did you want to put slides up, or do you want me to share my screen? Okay, so let me just jump over. And I'm just going to change up the. There we go. Okay, so given that this is a hackathon, we wanted to talk today just about some of the things that can have an impact on technology projects. And I think in general, when you're building anything related to crypto assets, it's important to think through the regulatory implications in the various jurisdictions where you might be either centered or serving customers. Both of those things can have a pretty large impact on your business. And one of the things that I think ends up being unfortunate with some of the startups that I see is that sometimes there's a project that's half built before someone has the realization that, oh snap, there are different legal and compliance requirements that we might be offside with. And so we wanted to give a little bit of flavor for those about where various regulation and regulators might touch your world. Both my practice and Laurie's practice are Canadian. And so by all means, please fire away with all of your questions from the Canadian context. If you have questions about the nitty-gritty of US law or another country's law, we are probably not the right people to ask that, but if you wanted to send either one of us an email, we can try to put you in touch with folks that we know in those jurisdictions. And this is particularly prescient on this side because on the slide rather, because as technology builders, I think the major issue that we see, or the major point of tension, is that technology itself tends to be global and very fast. So I can deploy an app, I can put it out in the App Store, and it can be everywhere in the world tomorrow. When it comes to law, when it comes to regulation, it is slow to change. It is slow to even get an answer sometimes about how existing law applies. There's a lot of nuance there, and it's very much local. So the law in one jurisdiction isn't going to protect you in another jurisdiction. And although I've seen some things that I would consider relatively noble attempts to have a global law, and I think an interesting example of that during ICOs was the idea of a SAFT, so that you could have this universal token issuance guideline. The problem with that was it wasn't actually compliant in any jurisdiction that I'm aware of. And so people had, with like the best of intentions, developed this beautiful framework But when it's not actually aligned with the laws of the jurisdiction where this activity is happening, you can still end up being quite offside, and in some of those cases, either facing regulatory penalties, having to give the money or the crypto back that you've raised. And none of those things are super pleasant for anyone. In terms of crypto assets, I just wanted to talk through some of the types of business models that we see. And I would ask for folks, by all means, please feel free to drop different questions or business models in the chat if you have a what about, and we'll try to address those as much as we can. The first one that I think everyone has pretty much internalized at this point is the virtual asset exchange. So if you're exchanging crypto to crypto or fiat to fiat, that's going to be regulated from an anti-money laundering perspective in some sphere. I think this gets really interesting in terms of exactly how that's done. And I'm going to turn it over to Laurie at this point to talk about custody, which is a fascinating line in the sand that's been drawn in the Canadian regulatory space.
Sure, thanks, Amber. I would have been happy to talk about SAFs as well. So if anybody wants to talk a bit more about SAFs and sort of what has happened to SAFs since that time, because they are definitely being used, but they are being tailored to the laws of the jurisdiction where they're being used. And as Canadian counsel, we'll often, get a form of SAF that's been developed in the US or in Singapore, and we'll need to sort of build in language to tip our hats to, compliance with Canadian securities laws, Canadian AML, et cetera. So that's sort of how that global becoming local approach sort of happens. But I guess just custody, which is what Amber sort of passed the ball to me on, is sort of a favorite topic from the perspective of securities regulation, because it is really the feature of crypto asset trading platforms in particular, but also other, crypto asset client-facing applications that have given rise to a lot of regulatory concerns in Canada, in other jurisdictions as well. But in Canada, the way that we're dealing with it is kind of unusual. And a lot of this, I think, goes back to Quadriga, which is sort of where the custody saga began. But really, after all of those losses among the Canadian retail investors using the Quadriga platform, which losses were just attributable to good old-fashioned fraud, really nothing to do with the fact that it was digital assets, although it did make that easier for Gerald Cotton, I think, and his team to perpetrate the fraud. It just created like a pretty significant concern, investor protection concern at the level of the Canadian securities administrators. So we have provincially regulated our securities laws are provincial. So the way that it works is every province has a regulator and they all get together in this group. It's sort of an informal umbrella organization called the Canadian Securities Administrators, and they try to come up with common approaches and standards. So they all agreed, we can't have these, we can't continue to allow retail investors to buy crypto assets from trading applications and platforms in Canada that, maybe even those that are registered under AML, the AML requirements, which is where Amber's home is with FinTrack as a money services business. If after they sell their crypto assets to the Canadian customer, the customer keeps their assets on the platform in an account at the platform, rather than, doing an on-chain transfer of the crypto asset into a wallet that is entirely owned and controlled by the customer. Our regulators, look at this and they say these Canadian retail investors are at risk to the platform, because if the platform disappears, goes bankrupt, commits a fraud, gets hacked, they're basically any kind of risks and vulnerabilities associated with the platform are going to impact these Canadian retail investors and their ability to recover their assets. So in response to that legitimate and well-placed investor protection concern, our securities regulators have decided that the account that a Canadian retail investor has on a platform with a crypto asset trading platform is itself a security or a derivative. And it's looking more and more, and this, Amber, this is new, it's looking more and more like all of the regulators are going to be regulating this as a security, not as a derivative. The AMF in Quebec seem to be more comfortable with the analysis that this relationship is a derivative and we're regulating it under the Derivatives Act, whereas the rest of the country was regulating it under the Securities Act. New intel from Quebec says that they're capitulating, so at least the whole CSA is going to be regulating it, in our view, still incorrectly, but at least all under the same law, same interpretation. So anyway, the point of telling you all this is that if you're, whatever technology you're developing, and putting out there in the ecosystem is going to potentially have a custodial component to it, so that assets that, the customer is deploying to your app, for example, even if your app is like a DeFi protocol where, digital assets can get deposited into a smart contract and then used for some other purpose. If there's an identifiable management team that's, responsible for running that technology and making sure that it's operating properly for a period of time until it gets completely decentralized and fully, autonomous, which is what we all want, there is a risk that the securities regulators are going to take the position that you or your management team or your application are doing something that should be getting regulated under not only AML rules, but also securities laws. So it's something to be very mindful of. And if you want to, if anybody has fact patterns or examples of things that they're thinking about doing, we can sort of talk through some of those examples. And we can also talk about how you might want to manage your regulatory risk if you do find yourself kind of on that line or walking that line. So I'll pause there and see if this is there are any comments or thoughts arising out of this issue. I think I see a few things in the chat. Oh,
yeah, hi.
No.
Can I say something?
Please do.
Yeah, hi Amber, hi Laurie. So my name is N Canada. I am the CEO and founder of Black Magic Bank. The kind of elevator pitch is it's going to be a US federally regulated credit union that abstracts and packages DeFi block kind of modules for consumers. And I've been in talks with the National Credit Union Foundation in the US, and I guess I'm trying to kind of figure out how to navigate that space, because my biggest concern is to safeguard people's money in the risk in interfacing with DeFi protocols. So I'm kind of trying to find people to figure out and to navigate that space, because I have some front-end experience and my background is actually in chemistry. So I'm kind of new and I'm trying to break in because I feel like I have a great idea, a great product, and I think it could really help a lot of people.
Can I pop in first, Amber, if that's okay? So that's really cool. I like the idea of getting regulated as a federally regulated credit union in the US. That sounds like an ambitious undertaking, but something that if you achieve it is going to put you in a very good position, even if you're looking to expand into other jurisdictions. Especially I find in Canada, and it's probably because of where we sit, being north of the United States, we take a lot of comfort from foreign regulatory regimes, provided that they're robust enough. And, prudential regulation, sort of regulation of deposit taking, is definitely something that gives our regulators a lot of comfort. So I get, and I also work pretty closely with a few service providers in the US, as Amber mentioned, that sort of are looking at that. And not only, there's actually recently I started talking to a consulting firm that it's all full of lawyers, but they're not actually practicing law anymore. They're doing consulting and helping like the challenger banks, challenger fintechs to figure out like, what's the best license for me to get? What's the best path to get that license? Particularly when we're looking at, they're looking state by state, you're looking at a federal regime already, but just wondering how far down the road are you? Do you have any advisors in the US already? Like, what are you sort of looking for at this stage?
Yeah, so actually my last name is Canada. I'm not in Canada. Like, I know my name. So
is that really, or that's not like a pretend, like,
no, that's my legal name.
That's awesome.
So, so I have some, Canada love as well. But, so I think I've had initial conversations, but the biggest hurdle for me was liquidity, right? So I talked to the National Credit Union, the US National Credit Union Bureau, and one big thing is that it was talking about collateralization, right? And with the stablecoin protocol, especially like Circle, which is US based, I just need to figure out if I can, use these sort of things, because there's no, I try to talk to Circle, they have no idea. So it's like I'm in a new realm. So I'm trying to figure out, can I use, a USDC to be over collateralized, and will the US accept that? And, then can I custodian people's money and then, leverage that on the DeFi, in the DeFi space, and then give them their returns as the custodian. So like, how far along am I? I'm just trying to like build everything right now and get those skills, but I don't have any mentors. I don't have any advisors. And that's kind of why I'm doing hackathons, why I'm, out here trying to say, I think this could change everything. And especially for marginalized people, for disenfranchised people, a credit union, and also for like millennials and Gen Zs, like it's like Robinhood legit, right? It's like, a bank for the people. And, using DeFi, that infrastructure, that's like bank infrastructure public. And I, as an individual, can build a business that gives people access. And that is just, I think revolutionary.
There really are incredible parallels historically between the credit union movement and the crypto asset movement, just in terms of equity and power sharing and philosophy. So I think there's so many fascinating parallels. I suspect that you probably need an American version of Laurie. And I say that knowing a little bit about the mechanics of some of the 3IQ arguments and what happens when you're doing something that's new, but you're leaning on what's been done historically. I would say, can you drop your email in a DM on here to Laurie or myself, and we'll just make sure that we're putting you in touch with folks that are potentially good advisors in that regard.
Yeah, I'll put my email, and then I'll put my Twitter as well. Amazing.
The other thing I would say is never underestimate the incredible value of security audits on the technology side. There are companies that do just really phenomenal code and security audit work, and you want to make sure that when you're ready to deploy, that's something that you're engaging. I think some of the biggest risk that you see in this space, it's not about money laundering, and it's not about where you fall in the regulatory spectrum as much as it's about, can someone cause a flash crash to have your protocol to be drained? And those are big, real issues. And it takes someone that really understands the underlying mechanisms in order to do a proper technology audit. One of the principles that I love in tech audits is that the idea that you're supposed to audit things that are 75% or less of your capacity in terms of what you could actually build or code, which is to say that I, as a script kiddie, probably don't need to be auditing Bitcoin Core's code, because I'm just not at that place. That's not what I can personally audit from that perspective. So I think it is really difficult to find the right people to look at things on that code audit side when you're doing something new. But I can't understate the importance of looking for that and trying to get that in place.
Yeah, I mean, I'm totally looking for advisors, for people to help me. The team currently is just me. And I've been, bootstrapping this. I've been, working on this on the side, building my website, trying my best. So I'm trying to, get this to be and I think the reality is it's all there, right? It just is going to take someone to put everything together and then say, here's the product for the consumer. And I think I can be that person.
That's very cool.
There's a consultancy, and I'm just trying to figure out the name. Oh, I think I just found it. FS Vector, that's what it is. I'm just going to give you a link to a website in the chat here. I think that they could be super helpful to you. They would be kind of like, I would suggest, a first step, because they really are. They do advisory work that's not, quite lawyer work, which means also that I think it's more affordable. I know everybody's looking, I know that you want to figure out something out that you can, they'd certainly, I think that they would definitely be willing to have some kind of initial chats with you, also just hear about what you're doing and give you some feedback, like without, going on the clock. I do that all the time with startups. But these guys are like so deeply connected to all of the different layers of financial services, regulatory, options in the US, that I just think he would be a great first person for you to talk to. And if it looks like something interesting, I can do a warm intro to you, to one of the principals there. So feel free to reach out to me also. I'll just put my email address in here and we can take it from there.
Yeah, absolutely. Thanks, guys, so much. I'm super excited about this. I've been working on it for about like 4 months now, developing the idea and everything. And, I have a long-term plan, 5-10 years. I'm not in any rush. I think this needs to be done well, and, launch MVP and make it successful. I think it's going to be really hot.
Cool.
That's amazing. By the way, I love that you started by talking about, when you said the word bank at first, I felt a little bit of, uh-oh. And then you said, but it's going to be federally regulated and here's what it's going to look at. And that was perfect.
Exactly.
One of the things, yeah, just the word bank, even if you're not actually planning on being a bank, tends to invite certain regulators and certain attention into your world. And so if your project isn't actually planning on being a grown-up bank, so to speak, please don't use the word bank, but you are, which is fantastic.
Thanks, guys. I'll reach out to you, Laurie. Thanks.
Sure.
I have a question. I'm Matthew. Motor. Motor actually, yes. Motor actually means mode of transfer alternative. It's going to be some sort of a remittance solution. My concern here is that key to our project's objectives is to protect ordinary non-technical persons, particularly in West Africa, from fraud. However, in the same environment, ecosystem, what is referred to as regulation becomes some kind of restriction. What do I mean by this? For instance, within our ecosystem or within this part, we can't access some stocks in certain parts of the world. We can't access certain payment systems in parts of the world. To date, PayPal is not accessible in Ghana, where I am. In things like trade, there are limitations. So these things are not regulations, but restrictions to us. So when looking at crypto-based solutions, we are, whilst looking at protecting locals, maybe semi-illiterates, illiterates from fraud, we at the same time are looking at breaking some of these restrictions which prevent genuine businesses from interacting with businesses outside of this region. So in this light, a solution like ours, how do we navigate this complexity where we are trying to remove or overcome certain restrictions, at the same time trying to protect people from the risk of fraud, etc.?
I think that's always going to be a balancing act. And a big part of that is going to be understanding, again, where those businesses are that you're going to be interacting with, where the customers are that you're going to be interacting with, and what they're beholden to in terms of laws and regulations. So the piece that Laurie was talking about in terms of custody is what's happening in Canada. It's not necessarily reflective of what's happening globally, and that's fairly important to know. From an anti-money laundering perspective, there's always, because it's part of the Financial Action Task Force's guidance, So generally speaking, you would expect a lot of different virtual asset businesses and a lot of traditional remittance businesses, in fact, all of traditional remittance businesses to be captured in that. And so it will really come down to having that nuanced understanding of what applies to your jurisdiction and what applies to those partners that you want to work with. I think we definitely see in the anti-money laundering world a lot of things that are unfortunate, where institutions will actually cite that they're not working with particular jurisdictions wholesale because they see that jurisdiction as being prohibitively high risk. And so I think to the extent that you can, understanding that and trying to work with those parameters, trying to understand why that's the case will help you unlock some of those things. And in certain instances, that might take a lot of time and a lot of effort. But I think in the long term, it's worthwhile.
Thanks.
Any other thoughts for Matthew, Laurie?
I guess I mean, I've heard, I've heard from a number of kind of remittance solutions or payment solutions, particularly focused on Africa, because there are so many challenges there. There's challenges within and also, cross-border remittances and payments, and using blockchain to kind of overcome some of those challenges. I remember talking to a client a couple of years ago that was saying that, some of the local money services businesses here, in order to have relationships with the other side of an international remittance in certain parts of Africa, I can't remember if it was Senegal we were talking about, but they would, maybe it was Zimbabwe, I really can't remember, but they described it like literally going on an airplane with suitcases full of cash and bringing that cash to the receiving kind of local money services business to keep in a sort of trust account to secure the payments that are going across. And like that shocked me that that's actually that is a thing. It's scary and it's unfortunate. And I do believe that one of the great powers of the blockchain should be to democratize payments and make things more safe and make things more equal, like in the world. And there's one developer that I just want to mention that I've just recently been directed towards to look at on behalf of another client called KoraPay. I don't know have you heard of those guys? It starts with the K, KORAPAY. And I think that at least part of the developer team is based in Toronto, but apparently they're sort of building a solution. I don't know what it may or may not have in common with what you're trying to do, but have a look on their website and see if there's anything interesting there.
I'll do that. Thanks.
Excellent. I want to switch gears and talk just a little bit about the issuance and sale of virtual assets, because I think that's a space that gets really interesting in that there are platforms at this point that will just let you spawn a token if you want to. So in the time that we've been talking, I could have pressed a few buttons and sent a few Bitcoin or well, not a few Bitcoin, a few sats or some ETH, and spawned a token of whatever sort I wanted to. But there are a lot of implications when you actually do that. From a Canadian perspective, the regulator has said that if it's a cryptocurrency, so if the intent is that it's going to be something that you're using to buy things, that you're using to actively trade, then there's an expectation that it's covered from an anti-money laundering perspective. So you would end up potentially being an MSB as an issuer. But I think here again, there's a lot more tension on the securities side in terms of what is your token actually doing, and can it be seen as a security?
And just to add to that, even if your story of your token really strongly points to it being a utility or a commodity, and it has like a great use case on a protocol or on a blockchain, if the developer team / management team / promoters are actively engaged in encouraging encouraging distribution, and this is, you know, becoming more common, especially with sort of, you know, IDOs, they're calling it now, when you just sort of set up a liquidity pool on Uniswap. So if you sort of want to seed your token by setting up your own liquidity pool on Uniswap, and then kind of tell your network, by the way, this is happening, and provide some information about like what the token does and why it's a good thing to own, that will raise securities regulatory risk for sure in North America, no matter how legit the actual utility of your token is. So, and I mean, that's come across very clearly in the SEC complaint against Ripple. So you need to be very careful about your communications. I've been thinking about, as a securities regulatory matter, how effective it is in terms of protecting yourself to include disclaimers that basically just say that just say like, this is not intended for North American audience, or this token should not be purchased by North Americans right now. Like, that just might not be sufficient. Like, because everybody knows how the community works and how communications work. And if you're sort of saying one thing for the purposes of taking a formal position, but then actually doing something else, being, you know, potentially deliberately doing something else, but you know, at minimum being willfully blind or grossly negligent about the risks that your messaging will end up soliciting North Americans, you could still run into problems. But just to analogize it back to the securities world, you know, when you look at a press release, so if you're a Canadian issuer that's a public company in Canada, but then maybe only available on a private placement basis in the US, you publish press releases, you issue press releases all the time. And the press releases always say across the top of them, like, not intended for the US, not intended for dissemination in the US. And that seems to be something that has been accepted practice in the securities world for many years, notwithstanding the fact that everybody knows that everybody can see press releases and they're available, you know, all you need is an internet connection at this point. So it's kind of like, is it appropriate or fair that a higher standard is being placed on blockchain developers than exists for securities issuers? So those are some of the things that I'm trying to grapple with, because I'm trying to advise developers and help projects be successful, notwithstanding that the regulatory framework in North America is extremely restrictive, but knowing that the regulatory regimes in other parts of the world are a lot more open. And this sort of goes back to Amber's, where did that cool picture that you made go? We never showed it. That regulation is local, but the blockchain and the products are global. So I'm trying to figure out arguments that can be made, even sort of positions that can be taken in with the regulator that says, this is not an unreasonable thing to do. This is truly a global opportunity, and it's reasonable for developers to put that out there and make it clear that, you know, the laws are not the same in local jurisdictions. And so I think that there's a gray area here for sure, where we can't really give like a high degree of comfort from like a securities regulatory perspective, but we can give like practical tips about how to set yourself up for success, so that if you're willing to take on some regulatory risk, you can at least tell a story where it's like you turned your mind to it, you did your best to comply with the rules to the extent possible. So those are kind of some things that we're looking at, and we have at OSLER at least, and it's an area where, you know, when you're practicing in digital assets, you need to sort of talk to the people, you talk more broadly out of digital assets to people that have been sort of practicing securities law for a really long time, because it's helpful to get that like gut check from, you know, the more traditional industry about how, you know, what positions are too aggressive.
There, I love it. I'm mindful of time, although Jerry said it was okay that we go a couple minutes over. So at the point where you need to drag us off stage, just drop us a quick question. There is something I wanted to ask, because it's something that I hear again and again in terms of various models, and that's really talking about fractionalized assets. where there's comfort that the idea that, okay, so I've made an NFT and it's on a blockchain and I've sold it, great, I'm being compensated as an artist. What happens when that becomes fractionalized and people can own part of that art? And does that have an impact on how regulation touches the product?
So what happens is it becomes a security or a derivative. Like, that's a big heads up to everybody here, because I know that fractionalized NFTs and NFT marketplaces and sort of doing NFT auctions, fractionalizing an NFT, auctioning it off, and then sort of putting it back together and participating in upside is a big business model that I've been seeing quite a bit lately. And from a securities regulatory perspective in North America, sort of I think that's a hard no in terms of securities regulatory risk. But again, it's an area which is which is complicated because it's not. And there are clear regulatory frameworks in Europe and Asia that permit this exact thing and are pretty clear about it not being a security, but because the sort of virtual asset regulatory framework is more developed there, or there's a home for these types of service providers, and they do have to do, real FATF compliant AML, which is really where the risk is. It's not really, the risk of it being a risky asset and you shouldn't have people participating in it. Well, when we're talking about the collectibles market, I think that the speculative nature of that is like very apparent, and nobody thinks that they're relying on a management team to be exerting efforts and there's no promises to do something in the future here. It's really just the way that the asset is structured that makes it a security in North America. So I think it's an area where the Europeans and the Asians are getting this right. And, we have some stuff to learn that we're trying to educate, our regulators and our politicians. And that's a real challenge, and that's a real uphill battle in Canada, because it's so, our rules are very traditional and very difficult to change.
I love it. What happens, and again here, I think this one gets really interesting. Just a couple of parting thoughts. If you're issuing something that's on a decentralized platform, and this is something that I hear a lot, from an AML perspective, the Financial Action Task Force, which issues guidance globally on how countries need to regulate from an anti-money laundering perspective, has definitely taken an interest in DeFi. And what they've said is that, well, a protocol that just exists on the internet, the intent is not to regulate technology, but when there is that identifiable group that is running it, that is profiting from it, then there is an expectation that that company is going to be pulled in and be regulated. And that's something that I think gets particularly interesting. Is the same tension there on the securities side, Laurie?
Sorry, just repeat that again.
So it's the same tension there on the securities side in terms of, is there the risk that something is a security even though it's theoretically decentralized or moving towards decentralization?
Well, what you described is exactly the issue, is that as long as there's that identifiable group of people whose efforts are, the success of the protocol and the value of the token are connected to a group of people, we have an issue. One of my favorite stories is the Uniswap airdrop, because the way that the token Uni came to be really does, I think an opinion could be given that is not a security, because by the time the token was issued and it was sort of just dropped in for free into the account of anyone who had ever used Uniswap, it really was already decentralized. But and then my understanding is that it became listed on various exchanges, not through the efforts of any one identifiable group of others, but through, many different people, many interested developers and participants in the ecosystem. So even though there are clearly, the core developers who started Uniswap and who are benefiting from that token, because the technology became truly useful and decentralized before the token came out, it makes the story a lot easier to tell from a regulatory perspective. Because when you ask yourself, well, if the core developers of Uniswap disappear tomorrow, would that platform still be useful? Would that token still be useful? I think the answer is a resounding yes. So the likelihood the securities regulators could come back and say this was a distribution of securities when they didn't raise any capital from it at all, and the protocol and the token sort of stand on their own, I think it would be a lot more difficult to take that position. So that's it. If you guys are looking to if you're looking to structure a governance token in a way that I think lends itself to a good compliance story in North America, I think that's a really good one.
I have a quick question. Just hearing this, can you guys hear me?
Mm-hmm.
Loud and clear.
Yeah. All right, just hearing this, I mean, if Satoshi Nakamoto was actually listening to this before he started Bitcoin, he would be scared, i.e. the pseudonyms, because the idea of having to worry about regulatory concerns when you push a product out, sometimes basically in any environment or any innovation makes it that difficult. So from a legal standpoint or a regulatory standpoint, what comfort, what strategy should an entrepreneur use? Whereby, I mean, you've gone through the whole thing. I know it's people that are using pseudonyms and whatnot to try to get around that. But what really do you guys think, based on your experience, that is a good thing to use, whereby you don't have to, you can minimize that exposure for a team?
So, I mean, I think we've touched on some of these, concepts. One is that the rules are not the same all over the world. So this notion that, an investment contract is a security is very North American. My understanding is that the rules are quite different in Europe and Asia. So if there's a token that is more likely than not a security in North America, but unlikely to be a security in other jurisdictions, one, option that is being pursued a lot is to relocate or to put mind and management in jurisdictions that are friendlier and that have, have a different approach to regulation. Now, the issue that I see is that development teams that are, and a lot of the time we have these international development teams or global development teams where there are people from all over the world, and there happens to be one person from Canada or a few people from Canada that want to participate as a developer. And how do you manage that? So there are ways to structure, and especially if the development team wants, or, if there's contemplated that there are going to be some sort of founder issuances of SAFs or tokens to the founders as compensation to, legitimate compensation for what they've contributed to developing the platform. Well, those issuances can be done in compliance with securities laws in Canada and the US, because the issuances to the founders, the developers, can be done on a private placement basis. But then it's really the other activities that we talked about, the promotional and solicitation activities, the starting a market, making a market, getting liquidity early, like all of those types of things are where, if you do want to stay in North America, you're going to be more restricted in what you can do, and certainly how you might want to go about liquidating any of your tokens. So, so there are ways to do it, but you have to be careful, and you have to, like when you say hacking the rules and regulations, like I'm a lawyer, I'm not going to say, yes, hack them. I think, well, I guess it depends on what you mean by hack, but it's certainly like, being thoughtful about how a token is issued and to whom it's issued in jurisdictions where they would be securities, and also being mindful of AML requirements in those jurisdictions, and recognizing that if you have a global product but you need to comply with local regulation, as long as you're showing that you're thinking about the right things and doing the right things and seeking to minimize or not permit distribution that would be illegal, that's the right approach. Like a couple of years ago, I would have said, like, you just can't do it here. No ITOs, no ICOs, like nothing. But now that there's so much technology that facilitates, decentralized distributions of tokens without kind of going through the process of getting listed on an exchange where there's sort of active steps that need to be taken by the management team, there are definitely more options available. But I do think that, and there's always a question of like, how much regulatory risk, what's your risk appetite, and what kind of chances are you willing to take? And some are willing to take much more than others. But depending on where you fall in the regulatory spectrum, you should be getting securities regulatory advice and making sure that your documents and your customer-facing materials are consistent with the rules in the jurisdictions where you have clients and where you have people working.
100%. I think you don't get to ignore that there are regulatory obligations. When you're building something in the crypto asset space, I mean, you're not building Candy Crush that someone's going to play with on their phone. You're building something that interacts with people's money, with people's store of value, with people's ability to pay for goods and services. And it matters, and it matters enough that regulators have taken a different level of interest in it. You're going to need good advisors for the jurisdictions in which you want to do business. And I think the value of that can't be understated. I think we're probably just at time. In terms of closing, I wanted to say thank you for everyone here. Just thank you for building in a regulatory environment that is challenging and that has a lot of complexity. I'm a firm believer in the idea that if you can figure out the logic and systems of building on Bitcoin and building on Ethereum, learning to build from a regulatory perspective isn't all that different. It's a puzzle that needs solving, and thank you for doing it.
Like that. Thanks. Yeah, thanks for listening.